In a critical courtroom confrontation unfolding under the national spotlight, the Department of Justice, under former President Donald Trump's administration, has found itself facing mounting legal resistance over its efforts to swiftly deport migrants to El Salvador. Salvador. These deportations, executed under the Alien Enemies Act, have ignited a fierce legal debate centered on the rule of law, due process, and executive accountability. At the heart of the issue is the administration's attempt to bypass the legal safeguards put in place by the Supreme Court, which mandate that migrants targeted for deportation must be provided notice and the opportunity to file habeas corpus petitions. Critics argue that these rapid removals, described by some legal representatives as tantamount to kidnappings, threaten to circumvent fundamental human rights and potentially endanger the lives of those being sent to unstable and violent conditions in El Salvador. Leading the opposition are legal advocacy organizations, including the American Civil Liberties Union, a clue, which have mounted a structured, preemptive legal strategy. These groups have developed templated legal motions seeking class-wide injunctive relief, enabling them to respond quickly as new groups of migrants face removal. These motions, built upon a series of precedents established in recent court decisions, are designed to halt what many see as a pattern of rushed and opaque deportations by the Trump-era Department of Justice. Last Friday marked a pivotal moment in this legal saga. A DOJ attorney, previously found to have committed acts that prompted probable cause for criminal contempt, appeared once again before U.S. District Judge James Boasberg. In a notable shift from the administration's earlier defiant tone, the attorney assured the court that no deportations would be carried out in the immediate days ahead, pledging that migrants would be granted time to submit habeas petitions. This unexpected concession, however, was met with skepticism. Attorneys representing migrants remained unconvinced that the DOJ's assurances could be trusted. Their position, even with such representations, the risk of sudden deportations persists. Hence, they are pushing forward with legal procedures such as habeas hearings and class certification to guarantee due process for those affected. The concern is that without binding court orders, the government might resume deportations at any moment, claiming misunderstanding or administrative error. The judiciary, for its part, has responded with firm rebukes of the administration's actions. The Fourth Circuit Court of Appeals recently upheld a district court decision rejecting the government's appeal. Judge Diana Gribben-Motz, who issued the original ruling in Maryland, emphasized the need for transparency and adherence to established legal protocols. Most notably, Judge J. Harvey Wilkinson III, a Reagan appointee known for his conservative credentials, issued a striking opinion. In his remarks, Judge Wilkinson warned the administration of the long-term consequences of disregarding judicial authority. He underscored the notion that repeated defiance of both appellate courts and the Supreme Court would ultimately erode the legitimacy of the executive branch. His opinion, laced with an almost philosophical plea for constitutional fidelity, resonated widely across the legal community, capturing the gravity of the moment. Meanwhile, the spectre of criminal contempt looms over DOJ officials. Lawyers who misrepresent facts to the court may face personal liability. While a presidential pardon remains a possibility, it does not negate the legal and reputational consequences that accompany such charges. One attorney, known to be closely aligned with the Trump DOJ, now finds himself navigating a precarious legal path, questioning whether the administration he represents will ultimately stand by him. This tension has only grown more acute following Trump's public distancing from the legal proceedings. When pressed in the Oval Office about the rulings from Judge Boasberg, Trump disclaimed knowledge, suggesting that his legal team, not he, was responsible. For DOJ attorneys on the front lines, this was a chilling signal. Their loyalty might not be reciprocated. The implication was clear. If the administration's legal strategy fails, those executing it may bear the full brunt of accountability. Indeed, the broader message appears to be reaching its intended audience. Legal professionals, including political appointees serving under Trump, must now weigh the potential long-term fallout of defending executive actions that may not withstand legal scrutiny. While the administration has previously exhibited a bold, often combative approach to litigation, this latest episode suggests a potential recalibration. As the prospect of contempt findings grows more tangible, the tone has shifted, if only slightly, from one of confrontation to... Adding another layer to the unfolding legal drama is the question of political optics. While right-wing voices continue to frame the dispute in terms of partisan conflict, casting Democrats as overly sympathetic to undocumented migrants, the judiciary's response complicates this narrative. Judge Wilkinson's opinion, for example, does not come from a progressive firebrand, but from one of the most respected conservative legal minds in the country. His critique, therefore, carries significant weight within the Washington legal establishment and serves as a rare bipartisan bell. Behind the scenes, this case is also causing tremors among aspiring federal jurists and legal scholars. For many attorneys associated with the Trump administration, the question is increasingly one of professional survival. Aligning with a strategy that flouts judicial authority could jeopardize future career opportunities, especially in a field where reputation and integrity are paramount. As Wilkinson himself once served as a leading feeder judge for conservative Supreme Court clerks, his stance sends a message that resonates far beyond the courtroom. There are historical parallels as well. Trump's past legal entanglements have often left close allies vulnerable. Michael Cohen, once one of Trump's most trusted legal advisors, ultimately bore the consequences of the administration's legal brinkmanship. His experience serves as a cautionary tale for those currently defending similarly aggressive policies. As the legal proceedings move forward, observers are now watching closely to see whether this episode marks a turning point in the administration's approach or simply a temporary retreat under pressure. With potential contempt charges pending and mounting judicial skepticism, the administration faces growing pressure to either comply with legal norms or risk further institutional fallout. In conclusion, the confrontation between the Trump DOJ and the federal judiciary is not merely a legal dispute. It is a litmus test for the resilience of American constitutional governance. The actions taken in this case will not only affect the lives of vulnerable migrants, but also set precedents for executive accountability and judicial independence. As the legal community weighs in with increasing urgency, the question remains whether those defending the administration's policies will continue to press forward or begin to reconsider the cost of doing so. What makes this moment particularly consequential is the convergence of legal, ethical, and political tensions playing out in full public view. Unlike routine policy disputes, the unfolding battle over these deportations places the foundational principles of American jurisprudence under scrutiny. The questions being raised are not merely about immigration tactics. They concern the ability of the courts to enforce compliance when faced with executive resistance. Legal scholars warn that if the government is allowed to ignore or delay court orders without consequence, it sets a dangerous precedent. It sends a message that constitutional protections are negotiable and that executive authority can override judicial mandates at will. This is precisely why Judge Wilkinson's rebuke carried such gravity. He framed the administration's conduct not just as a policy error, but as a challenge to the structural integrity of the republic itself. Inside the Department of Justice, these events have led to deep internal unease. Some career attorneys have expressed private concerns over the legal reasoning being used to justify the deportations, particularly the interpretation of the Alien Enemies Act, an antiquated law passed in 1798, originally intended for wartime scenarios. Critics argue that stretching this statute to target modern asylum seekers, many of whom are fleeing gang violence and political persecution, amounts to a distortion of both the law and its historical purpose. Beyond the courtroom, advocacy organizations are mobilizing in response. Legal aid groups are coordinating with immigrant communities to ensure that those affected understand their rights. Public interest law firms are preparing additional litigation to challenge deportations on a case-by-case basis. And across law schools, the case is being studied as a potential inflection point, one that could shape the future of executive-legislative, judicial balance for decades to come.